from a structural point of view, within the trust, we distinguish a first subject, called settlor, who transfers a set of movable assets, whether these rights on immovable or movable property, company shares or other rights, to a trustee, for the latter to administer, manage and dispose of them for the benefit of one or more third parties, beneficiaries, in accordance with the provisions set out in the trust deed. The essential elements characterizing the trusts, according to the approach adopted by the famous Hague Convention of 1 July 1985, are as follows. 1. The separation of the trust assets from the settlors, trustees, and beneficiaries' assets. 2. The registration of the assets to the trustee. 3. The power and duty of the trustee to administer, manage and dispose of the assets according to the trust regulations or the law. The settlor should therefore, preliminarily, identify a person who can hold the title of trustee, who will have to manage the assets. With the transfer, the trustee, who can be a natural person, a fiduciary or trust company, becomes the owner of the assets moved to him, but he is not the owner in his own right. In the Anglo-Saxon system, it is customary to differentiate the position of the trustee, legal owner of the assets, from that of the beneficiaries, owners of a so-called equitable ownership. In any case, the impediments contained in the trust deed will prevent the trustee to enjoy himself the benefits deriving from the possession of the trust assets. It goes without saying that, in the act of constitution of the trust, must be accurately indicated, in addition to the identity of the beneficiaries, the ways in which they will derive and benefit from the assets, as well as the powers of the trustee. Furthermore, a fourth subject may be envisaged, the so-called guardian or protector, to whom to attribute the function of controlling and, at the same time, assisting the trustee in the management of the assets. He is often entrusted, by virtue of his own expertise, especially legal, to carry out a continuous activity of control over the trustee's competences. The main effect of the establishment of a trust is the segregation of assets, by virtue of which the assets constituted in trust form a separate and autonomous patrimony, a distinct mass, with respect to the assets of the settlor, the trustee and the beneficiaries, with the consequence that such assets cannot be enforced by the creditors of these subjects. Moreover, in the event of the death of the trustee, the assets will not enter the inheritance. In the event of the death, revocation or replacement of the previous trustee, the assets are transferred by right to a new trustee appointed according to the procedures set out in the trust deed. If you need specific advice, you can contact us at the email you find in the description. Remember that laws change all the time. Therefore, it is essential to check the law in force when you decide to relocate, move abroad, or create a trust. It is also very important that you speak to your international tax attorney before starting any type of tax planning or relocation of your business. Do not hesitate to contact us if you would like us to provide you with the contact information of highly qualified tax attorneys who are specifically qualified to help clients in your situation.